A few weeks ago, I watched a senior partner at a white shoe law firm review a candidate's file. On paper, the kid was a machine top of his class, 3 languages, a clerkship that most lawyers would kill for. But as the partner flipped through the pages, he wasn't looking at the candidate's trial history or his grasp of constitutional law. He was looking for a specific digital badge, a DEI gold standard certification. When he didn't find it, he tossed the folder onto a stack of rejects. Technically brilliant, he remarked with a detached sort of pity, but he lacks the performative fluency we require to mitigate risk. To this partner, legal acumen was secondary. The primary goal was signaling alignment with the right luxury beliefs. But then the atmosphere in that office shifted overnight. On February 3rd, a formal advisory from the FTC hit the desk, and the mood turned from smug moral certainty to a cold, sharpen-your-knives kind of panic. The letter didn't talk about social justice or corporate responsibility. It used words like collusion, labor market restriction, and antitrust violations. The government wasn't treating these DEI certifications as a moral evolution anymore. They were treating them as a cartel. A sophisticated non-tariff barrier designed by elite institutions to fix the price of talent and gatekeep the legal profession. Watching that partner's face go from the calm of an ideological observer to the frantic realization that his firm's hiring manual might now be evidence in a price-fixing investigation was a moment of pure cinematic irony. It raises a question that most in the legal world are too terrified to ask. What happens to a civilization when it's social adhesive? The law stops being about merit and starts being an antitrust struggle over who gets to define reality. We are entering a clinical autopsy of a system that forgot how to prioritize competence, and the results are far more clinical than you might think. And that wasn't hypothetical. Today is February 3rd, 2026, and if you haven't been, glued to the legal wires, you might have just missed a genuine earthquake.
It really is an earthquake. What you just described, that scene in the office, it's playing out right now. We are looking at a collision. I mean, a real high-speed impact.
A collision of what, exactly? It feels like so many things at once.
It's high-level antitrust theory crashing into the sociology of these elite law firms. And both of those are running headfirst into this concept of luxury beliefs.
It's a massive reframing of the entire conversation.
A complete paradigm shift
Yeah.
in real time. For the last, 10, 15 years, the corporate world, and especially the legal profession, they've been treating these ideological frameworks as social progress.
As a moral good, the right thing to do.
Imperative, exactly. But as of this morning, that lens has just snapped into a totally different focus. The government is no longer looking at this as social progress. They're looking at it as a market distortion.
That is a massive change. We've gone from asking, is this the right thing to do, to, is this illegal?
We need to parse the pathology of what's being called administrative bloat. We need to understand mechanically how that bloat ends up triggering these massive antitrust mechanisms.
Okay. Because this isn't just about, culture war talking points anymore.
This is about the cold, hard mechanics of the market. We're going to be digging into FTC warning letters, academic papers on ownership structures, and some really sharp sociological analysis to figure out why this is all coming to a head right now.
Here, we began with that partner, the one tossing the file. You said that's not just an anecdote, it's a symptom.
It's the key symptom. To understand why any rational partner at a multi-billion-dollar firm would throw away a brilliant candidate, you have to look under the hood. You have to look at the internal machinery.
And it seems like that machinery is breaking down. This reminds me of something I heard just the other day. I heard a story about a brilliant young litigator in D.C., the kind of mind that sees 3 moves ahead in a complex merger case. He spent his nights mastering case law, but his days were increasingly consumed by mandatory reflection workshops led by a chief diversity officer who had never stepped foot in a courtroom. The logic was clear. His billable excellence was a secondary metric to his cultural alignment. Eventually, the firm promoted a peer who spent more time organizing internal advocacy seminars than writing briefs. Try to imagine the quiet exodus of the truly gifted from these pillars of law, replaced by an administrative layer that values the performance of virtue over the rigor of the law. I read this and felt a chill. It's like watching a high-performance engine being dismantled by people who value the color of the parts more than the output of the machine. As a commentator, I see the frustration when the gatekeepers of justice are more worried about ideological signaling than winning a case. The very definition of merit begins to rot from the inside. Okay, let's pause on that story. Because, like you said, it feels like a scene from a movie, but it points to a very specific structural problem, this administrative bloat you mentioned.
Now, to most people, that probably just sounds like, too many middle managers, like, oh, we have too many meetings. But you're suggesting it's something more malignant than just being inefficient.
It's so much more than inefficiency. It's a fundamental change in the DNA of the institution itself. I mean, if you look at the history of the legal profession, especially these elite firms, they were built on something sociologists call a tournament structure.
A tournament. That's the old Cravath system, isn't it?
That's the one. It's named after Paul Cravath. And historically, the model was, well, it was incredibly simple and incredibly ruthless.
So
you'd hire a big cohort of associates, all from the top law schools. They're all brilliant. They all work absolutely insane hours. And from day one, they enter a tournament. And the tournament is based on one thing.
pure competence.
Pure competence and billable output. It was a classic up or out model.
Right. Make partner or you're gone. Exactly. You either won the tournament and became a partner, which meant equity, real wealth, a seat at the table, or you lost and you were politely shown the door. Absolutely. But it prized one thing above everything else: legal excellence.
So the incentive structure was perfectly aligned with the actual work. The client wants to win the case. The lawyer wants to win the case to make partner. The firm wants to win to get more clients.
Perfectly aligned. If you didn't win the case, if you didn't bill the hours, if you weren't the best, you didn't become a partner. The client's victory was the only metric that truly mattered.
But that's not what's happening in that story about the litigator in D.C.
Not at all. And that's because of the shift. The shift we're seeing is the rise of what you call managerialism over professionalism.
Okay. Managerialism versus professionalism.
Professionalism is the old Cravath model. Your value is your skill as a professional lawyer. Managerialism is about the institution itself. And over the last, say, 15 years, we've introduced this massive layer of non-productive bureaucracy into these firms.
And when you say non-productive, you mean they're not in the courtroom. They aren't litigating.
They do not generate billable hours, period. They do not practice law. These are your HR directors, your chief diversity officers, your vice presidents of internal compliance, your advocacy coordinators. From a purely financial perspective, they are cost centers, not profit centers.
But they hold power, a lot of power.
Immense institutional power. And this is the absolute critical point. Because they don't produce the actual product, which is legal victory, they can't justify their existence or their power through the traditional metrics of the firm.
They can't point to a case they won.
Right. They can't say, I won the Apple versus Samsung case. So in order to survive, to expand their influence and their budget, they have to create new metrics. They have to invent a new game.
You have to change the rules of the tournament.
Exactly. And this is where we get the performance of virtue that your story mentioned. They create new metrics for advancement that has nothing to do with legal skill. Instead, they rely on cultural alignment, on attendance at mandatory workshops, on using specific ideological language in emails.
So the young litigator in D.C., the one who's up all night studying case law, he's playing the old game.
He's playing the Cravath game.
Yeah.
But the firm itself, or at least the administrative part of it, is now playing the managerial game. And in the managerial game, his incredible billable hours are actually less important than his refusal to attend the mandatory reflection workshop.
Well, it's terrifying if you're a client, isn't it? I mean, if I'm facing a lawsuit, I don't care if my lawyer is culturally aligned. I care if he can keep me out of jail or save my company.
And that's what we mean by institutional decay. When you replace a hierarchy based on competence with a hierarchy based on ideology, the quality of the actual output, the legal work, it has to decline. It's inevitable. You are, as you said, dismantling the high-performance engine.
But this is the part where I always get stuck. Why would a firm do this? Logically, it seems like self-sabotage. If firm A starts prioritizing workshops over winning, eventually they're going to start losing cases. Then firm B, the, maverick firm that only cares about winning, they'll swoop in, hire all of the rejected geniuses, and steal all of firm A's clients.
The market should correct for this, right?
In a truly free and competitive market, yes, that is exactly what would happen. And it would happen quickly.
But you're saying that's not what's happening.
We're not looking at a free market here. We are looking at a market that is being, for lack of a better word, coordinated. And this brings us to this really important economic theory called common ownership.
Okay, I did read through the paper on this.
Yeah.
It's dense. It's all about airlines and big asset managers. But the core idea, if I've got it right, is that if a huge fund like BlackRock owns, say, 20% of United and 20% of Delta, they don't actually want a price war between them. They want, what's the phrase, soft competition? They want the quiet life. If Delta slashes prices to steal customers from United, profits for the entire airline industry go down. And since BlackRock owns a huge chunk of the whole industry, they lose money overall.
So they put pressure on the managers of both companies to just play nice, don't rock the boat, keep prices high.
You got it. And that leads to higher prices and lower output for consumers. It's a well-documented phenomenon.
Okay, I get that for public companies too. But I want to pause on this because it feels like a massive leap to apply that logic to law firms. I mean, Dentons and Hogan Lovells, they aren't owned by BlackRock. They're partnerships. They don't have some common shareholder in the background pulling the strings. So how do you get from airlines to law firms?
That is the million-dollar question. There isn't a common shareholder.
Yeah.
But there is a common certifier.
Common certifier.
Think of that DEI gold standard certification from your intro, or something like the Mansfield rule, which the FTC is now looking at very closely. Don't think of it as a trophy you put on the shelf. Think of it as a central nervous system that connects all these theoretically competing firms.
A central nervous system. It sounds a little ominous.
Well, it functions as a powerful coordination mechanism. In the airline world, the big investor sends a signal: don't compete too hard on price. In the legal world, the central certifier sends out a rule book. It says, here are the 40 specific granular criteria you must all use to hire. Here are the demographic quotas you must aim to meet. Here's the precise language you must use in your mission statements.
So they're effectively standardizing the HR department across the entire industry.
They're standardizing the inputs. If firm A, firm B, and firm C all sign up for that certification, and they pretty much all do because they feel they need that badge to attract and retain corporate clients, then they've all voluntarily agreed to use the exact same algorithm for acquiring talent.
And when you standardize the input,
you kill the maverick risk. Let's go back to your example. Imagine you're a hiring partner at firm B, the supposed maverick firm. You find a candidate who is maybe a little rough around the edges. Maybe he holds some unpopular political views. He doesn't have that polished performative fluency, but he is an absolute shark in the courtroom. A legal genius.
He's the unwoke genius, the guy the first partner rejected at the very beginning.
Now, in a free market, you hire that guy on the spot.
Yeah.
You unleash him on firm A and you win cases. But under this certification regime, hiring that guy costs you your gold star.
And losing that gold star means you might lose access to certain Fortune 500 clients because their own internal policies now demand that they only work with certified firms.
Yeah, so what do? You pass on the genius too. And because firm C is also certified, they pass on him too. And so does firm D and firm E.
So the shark, the actual top-tier legal talent, gets locked out of the elite market entirely.
He's locked out. And now the firms don't have to worry about him showing up at a competitor and beating them in court. They have collectively, if implicitly, agreed to exclude the disruption. That is the quiet life applied to the legal profession. It's not about owning shares. It's about outsourcing your most critical hiring decisions to the exact same third-party handbook.
Incredible. So the certification itself, it becomes the enforcer of the cartel. It's the mechanism that ensures no one defects from the agreement and starts hiring based on pure merit again.
That is precisely what the FTC advisory letter from this morning is arguing. That source, the U.S. competition watchdog, warns 42 firms. It's explicit about this. The FTC is warning these firms that coordinating on candidate pool characteristics, sharing sensitive data on diversity metrics to a central body, that can be a violation of antitrust laws.
They're basically saying, you think you're making moral choices, but from where we're sitting, it looks like you're fixing the price of talent.
And creating what's called a non-tariff barrier to entry. It's a classic concept in trade. To get a job in this elite sector now, you have to pay a toll. It's not a financial toll, but it's an ideological one. You have to invest your time and energy into acquiring this performative fluency.
Which excludes people who might be brilliant lawyers, but they either can't or simply refuse to pay that ideological tax.
And that leads directly back to the institutional decay we started with.
It creates, as you said, a clinical autopsy of merit. When you dismantle the Cravath system, which for all its brutality and its flaws was fundamentally about competence, and you replace it with a system based on these vague, holistic metrics defined by non-lawyers, the quality of the service has to suffer.
Because you're no longer selecting for the one thing the firm actually does, which is practice law.
You're selecting for compliance.
You're selecting for compliance. And this isn't just, some internal political drama. The FTC is now making the case that this is an illegal restraint of trade. By standardizing these costs, everyone pays for the same DEI administrative bloat, everyone agrees to the same hiring restrictions. You insulate all the incumbent firms from true merit-based competition.
It protects the partners. It keeps them from having to compete against a new generation of hungry, more competent, upstart firms.
It's meant to create that quiet life until the system starts to break down under its own weight, until the clients start to realize that the product they're paying millions for is broken.
Which brings us to the real-world consequences, because this isn't just an abstract game for lawyers in Manhattan high-rises. This trickles down. And we have to talk about who actually foots the bill for this quiet life.
And this is where the sociology of luxury beliefs becomes so critical to understanding the full picture.
You know, I saw a post online just last week. It was from a small business owner, I think in the Midwest somewhere. He had lost a foundational contract, the kind of contract his whole business depended on, because of a simple clerical error, basically. And the error was made by his legal team, a very prestigious, very high-priced firm in New York. The same firm, it turned out, had just overhauled its entire recruitment process to prioritize DEI certification over things like traditional clerkship rankings or law review. And you think about it, to the elite partners at that firm, these luxury beliefs, the idea that merit is a social construct that we should hire for other things, they carry zero personal risk. They're completely insulated by billions in assets and, their own personal wealth. But for that client, the mediocrity that got baked into this new ideological standard, it resulted in a devastating real-world loss of security. It's a completely asymmetric burden. The elites get the moral high ground, the status points, and the middle class pays for the resulting incompetence.
Thinking about this, I feel the weight of that unfairness.
It is so easy to champion these radical shifts when you are not the one who suffers when the system inevitably fails. And I understand the drive for social progress, I do. But we have to ask, who pays the price when good intentions result in a degradation of the professional standards that are supposed to protect everyone? That story it hits home because it moves this entire conversation out of the realm of abstract antitrust theory and into the life of someone who just lost their business. That business owner in the Midwest, he didn't give a damn about the law firm's diversity ranking. He cared about the contract being correct.
And his story is the perfect illustration of what we mean by luxury beliefs. This concept comes primarily from the work of the sociologist Rob Henderson, whose ideas are foundational here.
Let's define that term carefully for everyone listening, because it's a phrase that gets thrown around a lot and often misused. What precisely is a luxury belief?
At its core, a luxury belief is an idea or an opinion that primarily serves to confer social status on the elites who hold and promote it, but which inflicts real, tangible costs on the lower and middle classes.
Right. Henderson uses some really stark examples in his work, like the defund the police movement.
Or, say, rejecting the importance of the nuclear family. The core of his argument is that elites, who by and large live in very safe, often gated communities and tend to have very stable traditional marriages themselves, they adopt these beliefs to signal their sophistication and their virtue.
It's a status signal. It's the new Rolex. It says, look how progressive and evolved I am.
It's a way to distinguish themselves from the common person. But, and this is the key, they are insulated from the consequences of these beliefs. If you defund the police, the resulting crime spike doesn't happen in Beverly Hills. It happens in the poorest neighborhoods of the city. If you dismantle the cultural norm of the nuclear family, the elites still tend to get and stay married, but the working class suffers the consequences of the resulting instability.
So it's virtue for them and vice for everyone else. How does that map onto the law firm we're talking about?
It maps perfectly. The elite white shoe firm adopts these DEI certifications to signal its moral superiority within what's sometimes called the cathedral. That is, the interconnected network of elite institutions like universities, media, and foundations that collectively define what is good and proper.
So it's an admissions ticket to the elite club.
It's what the writer Mary Harrington, in The Pride of the Elite source, calls luxury Gnosticism. It's this idea that they're removing themselves from the messy, concrete concerns and realities of working people and ascending into this higher plane of pure theory and identity games.
And that story about the business owner, that's where the theory hits the ground, hard. Because we can talk about luxury beliefs as this high-minded sociological concept, but in that story, it's visceral. It's a typo on a contract that ruins a life.
It's absolutely visceral. And it perfectly maps out what we call asymmetric risk distribution. Again, think about the partner who made the hiring decision at that New York firm. He decided to prioritize cultural alignment over, say, a candidate's obsessive attention to detail.
Okay.
Now, when the case goes south because of a clerical error made by the person he hired, what happens to that partner?
Almost nothing. He's got his equity in the firm. He's got the house in the Hamptons. He still has the status of being seen as a progressive leader in his field. He can probably even frame the failure as a systemic issue or just blame a junior associate and move on.
Exactly. For him, the belief merit is a social construct we should hire for identity is a luxury good. It buys him social capital. It signals his virtue. He enjoys all the benefits of holding that belief, but he pays none of the costs.
The cost is exported.
It's completely exported. It's sent downstream to the guy in the Midwest, the guy who needs the contract to be right because he has a mortgage to pay and employees who depend on him. When the luxury belief results in real-world incompetence, a simple clerical error, the partner loses, maybe a little bit of pride. The client loses his entire livelihood.
It's almost a feudal arrangement. The lords in the castle get the prestige from their enlightened beliefs, and the peasants in the field pay the price when the crops fail because of it.
And that is why this concept connects so strongly to the idea of economic precarity. One of our sources, Silicon Valley and the Venture Mode, introduces this haunting term, neglectscapes.
Neglectscapes. Wow. Heard.
And it refers to these institutions that have, for all intents and purposes, abandoned their primary functional duty, which is to provide security and stability while their leaders engage in these abstract status games.
And the law is supposed to be the opposite of that.
The law is supposed to be the ultimate meritocratic promise of protection. The idea is that if you are right on the facts and you have a competent lawyer, you should win. That is the foundational promise of the system.
But if the system is rigged, not by money, but by ideology,
then that promise is broken. The institution becomes a neglectscape. It is actively neglecting the average person's fundamental need for competence in favor of the elite's insatiable need for moral validation.
And that feels like a very dangerous situation, because if ordinary people stop believing that the law is about competence, if they start to see it as just another arena for political signaling based on who has the right badges, then the legitimacy of the entire system begins to crumble.
And that sense of betrayal, particularly among the middle and working classes, is exactly what fuels populist backlash. It's the reason people stop trusting institutions, and ultimately that growing instability is the reason the regulators finally had to step in.
Which brings us to the intervention itself, because for a very long time, I think most people assumed the government would be on the side of these initiatives, but on February 3rd, the entire script flipped. There's a narrative circulating, almost like a piece of legal folklore at this point, about a veteran regulator, a lifer. And he had this epiphany. He realized that this DEI cartel among the elite firms wasn't just a cultural trend. He saw it for what it was, a classic textbook antitrust violation. He looked at how these firms collectively agreed to enforce these ideological hiring standards, and he saw that they were effectively creating a closed shop, a system that barred anyone who didn't subscribe to a very specific political orthodoxy. It functioned exactly like a price-fixing ring, but instead of fixing the price of widgets, they were fixing the market for human intellect and talent. And so he began drafting a new framework for the FTC, a way to treat ideology antitrust as a clinical surgical tool to break this monopoly on professional entry. I mean, can you just imagine the tension in those mahogany row offices when they suddenly realize their progressive certificates might now be treated as Exhibit A in a collusion case? When I look at this, I see a desperate, almost frantic attempt to return to a neutral marketplace. Now, it's a harsh, you could say right-leaning perspective on intervention, but it highlights this profound anxiety. If the market for ideas itself is rigged by an ideological cartel, perhaps the only way to save the system is to use the raw power of the law to force it back to objective competence. It's a radical solution, but it's a response to what many see as a radical corruption of the American meritocracy. Ideology antitrust, it completely reframes the entire battlefield.
It's a total paradigm shift. And we really have to unpack the legal logic here because it is logical. The regulator in your story, he isn't making a moral argument against diversity, is he?
No.
He's making a functional, mechanical argument against collusion.
Let's look at the FTC's argument. Based on that source, U.S. competition watchdog warns 42 firms. What specifically are they targeting? What's the mechanism of harm they're pointing to?
They're targeting the coordination. Plain and simple. The warning letters that went out this morning to firms like Denton's and Hogan Lovells, they focus on things like the Mansfield certification.
This is the digital badge we talked about at the very beginning, the gold standard.
That's the one. And the FTC's argument is that by participating in this certification, these competing firms are doing two things that are highly suspect under antitrust law. One, they're sharing sensitive non-public data about their hiring metrics and workforce composition with a central third party. And two, they are setting collective goals based on that shared data.
In antitrust terms, that looks an awful lot like competitors getting together in a room and sharing their pricing data to fix the market for, say, steel.
It looks exactly like that. It's distorting the competition for labor. That's the legal phrase. If all the big, powerful firms in a market agree, we will only hire candidates who meet criteria X, Y, and Z, they have, in effect, created a closed shop. They have organized a group boycott against anyone who doesn't meet that ideological criteria.
And group boycotts can be illegal. But wait, I thought boycotts were protected free speech.
This is a crucial distinction. It's laid out in the source, the right to boycott. There's a difference between a political boycott and an economic one. A political boycott like, say, refusing to buy grapes to support striking farm workers. That is generally protected speech under the First Amendment. But an economic boycott, one that is organized by a cartel of competitors to stifle competition, that is not protected.
Is there a legal precedent for this?
A huge one. It's a famous Supreme Court case, FTC v. Superior Court Trial Lawyers Association.
The trial lawyers case, right?
Yes. In that case, a group of public defenders in D.C. all agreed to stop taking cases. They boycotted the system until the city agreed to pay them higher wages. They tried to argue that this was a political protest to improve the quality of the justice system.
Good.
The Supreme Court said no. They said it was a straightforward violation of the Sherman Antitrust Act. It was a conspiracy, a cartel action to restrain trade.
So the FTC's argument today is that these elite law firms are doing the exact same thing. They are collectively restraining the trade of non-woke talent, for lack of a better term.
They are effectively boycotting a certain type of talent that doesn't signal ideological compliance. And the FTC is saying that is an economic restraint of trade, not protected political speech.
Okay, but I want to pivot here to the sharpen your knives panic that you mentioned in the intro, because honestly, up to this point, this sounds like a major regulatory headache. A few strongly worded letters, maybe a consent decree, a slap on the wrist. But then you brought up the Department of Justice and the False Claims Act. That seems different.
This is where the temperature in every corporate counsel's office in America drops about 20 degrees.
Why? What makes this specific law so terrifying for these firms? I always thought the False Claims Act was for, defense contractors who sell faulty helicopters to the Army.
It's the government's primary tool for fighting fraud against the taxpayer. But here is the new legal theory, and it is absolutely weaponized. Think about government contracts. Major law firms often work directly for the government, or they represent huge corporations that do.
Okay.
Now, to get those contracts, the firm has to sign a document. And on that document, they have to certify that they comply with all federal civil rights laws, which means they do not discriminate on the basis of race, religion, sex, and so on.
Right. It's a standard form. We do not discriminate on the basis of race. Check the box, you sign the form, you get the government check.
But the DOJ's new civil rights fraud initiative is advancing this theory. If you sign that piece of paper, certifying under penalty of perjury that you don't discriminate, but your firm is simultaneously running a DEI program that effectively imposes quotas or gives preference to certain groups or excludes candidates based on race or even political views in order to meet a third-party certification target, then you lied on that form.
You have committed fraud against the United States government.
You have submitted a false claim, and the penalty for violating the False Claims Act isn't just a fine, it's treble damages.
Treble, as in triple.
Triple. So let's just do the math. Let's say your firm has billed the federal government $50 million over the last 5 years on contracts where you certified your compliance.
You don't owe $50 million back. You owe $150 million.
$150 million plus penalties. Now, for a partnership structure where that $50 million in profit has already been distributed to the partners and spent on mortgages and tuition, an unexpected $150 million liability is an extinction-level event.
That is why the mood shifted from smug moral certainty to sheer panic. It's not a PR problem anymore. They're fighting for their bank accounts and the survival of the firm.
It completely changes the calculus.
It's like it weaponizes the law back against the lawyers. For years, you had this long march through the institutions where these ideologies were embedded. Now the state is using these very clinical, powerful tools, antitrust and fraud statutes, to march right back in and dismantle them.
And it sets up this massive clash of worldviews. I mean, a truly fundamental disagreement about the purpose of these laws.
And the source on distributional reinforcement theory lays this out perfectly.
To really grasp the magnitude of what's happening, you have to understand the philosophy that's being dismantled. The old view, the one that was dominant until, well, this morning, is this idea of distributional reinforcement. In simple terms, it's the argument that equality isn't a static thing, it's malleable. It argues that because of historical injustices, the system is inherently biased. Therefore, to achieve true equality, you must actively intervene. You must reallocate resources and opportunities. You must consider race in order to achieve racial balance.
It's the equality of outcome argument. If the outcomes aren't perfectly equal across demographic groups, you have to go back and rig the inputs to make them equal.
And under that theory, a little bit of discrimination is actually seen as a good thing, as long as it's correcting for a perceived historical imbalance. But the new view, which is actually a return to a much older classical liberal standard, is a strict adherence to colorblindness and merit.
The ideology antitrust view.
Exactly. The FTC and the DOJ are now enforcing a very clinical, functionalist view of the law. They're saying competence must be the only legally permissible metric in the marketplace for talent. Any deviation from that, even for what you believe are good social reasons, is a corruption of the market. It is a collusive cartel action.
So the government is effectively saying, we don't care about your stated social goals. We care about market efficiency and open competition. And your social goals are creating an inefficient, anti-competitive market.
That is the argument in a nutshell. It treats the ideology not as a philosophy to be debated, but as a defective product that is gumming up the gears of the American economy.
What's fascinating about that approach is that it completely strips away all the moral language. It doesn't get into a debate about whether DEI is good or evil. It just says it's inefficient and collusive.
And that is a much, much harder charge for a law firm to defend against. They can argue about morality all day long, but they cannot stand up in federal court and argue that they have the right to fix prices or illegally restrain trade.
Cool. We've gone from that single candidate's file to the deep sociology of the firm. We've examined the impact of luxury beliefs on real people, and we've ended up here with the antitrust hammer about to fall.
It really is a clinical autopsy. The body is open on the table, and we are seeing with surgical precision exactly what led to the death of the old meritocracy.
And the mission of this FTC intervention, then, seems to be to strip away that ideological layer, to force these institutions, maybe for the first time in a decade, to look at a candidate and just see a lawyer, not a demographic data point or an ideological signifier.
It forces a return to objective reality. A world where 2 + 2 must equal 4, where a contract must be legally sound, where the performative fluency doesn't matter one bit if the bridge falls down or the client loses the case.
Yeah.
And it leaves us, I think, with a very heavy and very sobering realization.
What?
We are witnessing a moment where the state is using the cold, hard market logic of antitrust law to deconstruct a moral hierarchy. And it forces us all to consider a really uncomfortable question. If the legal profession effectively organizes itself into a cartel of ideology, does it lose its fundamental legitimacy to practice law at all? This autopsy suggests that when you sacrifice competence for performative fluency, the system doesn't just become unfair, it becomes clinically dead.
When the law stops being about the law, we're all in trouble. That's the deep dive.